Experienced adolescent guardianship lawyer, New York Family Law Group, guardianships attorney. If you are seeking guardianship of an adolescent or minor under 17 years of age, navigating the process can be difficult. What is guardianship? A guardian or legal guardian is a person or agency that has full authority to be responsible for a child's care. These rights may be granted to a child under 18 years of age, or 18 to 21 years old if the young person consents. This is very similar to custody and adoption. A person petitions the court to be legally responsible for the care of their child, their guardian. They have the same legal power as a parent to make decisions for the child. However, unlike adoption, this is not a permanent relationship. The guardianship typically ends when the child reaches the age of 18, or 21 with the child's consent. When the child marries, or if the child dies. Who needs guardianship? Adult relatives, close family friends, and child protective agencies can all petition for guardianship. Guardianship may be granted in a variety of situations. For example, if both of a child's parents die, the child may need a guardian. Or, if one or both parents are deported but the child remains in the U.S., a guardian may be needed for their welfare. Guardianship may also be provided if a child is being abused and/or is in an unstable living environment that is not in their best interests. Before a legal guardian can be appointed, both parents and the child, if over 14, must consent, though guardians can be appointed without parental consent or the child's consent in some situations. A parent can also apply for a standby guardianship if they are sick and will not be able to take care of the child in the future. In this case, the guardianship does not take effect until the parent says that it will, for example, if they die, or become too ill to take care of the child. How do you become a legal guardian? To begin the process, you must file a petition for appointment of guardian in the county where the child lives. You will need to bring the child's birth certificate, original death certificate of the parents, if deceased, your proof of identification, such as a picture ID, proof of residence. How does the court process guardianships? Guardianship involves certifying the individual's disability and the creation of a report detailing how the special needs affect their ability to manage their affairs. A hearing will be called where both prospective and current guardians will have the opportunity to testify or provide information. It is important to establish clear guidelines regarding the duties of guardians and the tasks the ward may be able to handle. The courts have been very conservative in this area because guardianship is a transfer of rights between ward and guardian. A guardianship can be indefinite. However, any person can petition the court at any moment to alter or cancel an existing guardianship or to appoint a replacement or additional guardians. The ward has the right to petition the court, which provides protection from guardianship being improperly established or administered. The New York team of guardianship lawyers is skilled in the identification of cases where guardianship may be reasonably contested. This is crucial for families with individuals who have special needs. Take the time and set up complete guardianship agreements. It can be quite time-consuming. Parents with multiple children should clarify the guardianship issue as quickly as possible so that all parties are on the same page regarding care for siblings with special needs. What happens in a guardianship hearing? In a guardianship hearing, the court will determine if it's in the child's best interest to allow them to become their guardian. This will be based on your testimony, the evidence about the child's circumstances, the child's wishes, and all other applicable circumstances, such as the death or incapacity of one or both parents. Then, the court will make a ruling and issue letters of guardianship. Before the guardian's appointment can become permanent, they will have to undergo fingerprinting and background checks. Any person with previous child abuse or neglect case cannot become a guardian. If you wish to become the guardian of an adolescent, contact us at 718-293-1542 now for a case review and consultation, and see how we can assist you throughout the process.